Good afternoon, Your Honor.
Good afternoon. Who's up first? Mr. Lowe?
Mr. Lowe is ready.
All right, this is clause number CR 2381, State versus Daniel Keith West. Good afternoon, Mr. Lowe. All right, are you ready for arraignment? Have you had a chance to review the indictment with Mr. West?
Yes, sir. We've reviewed the indictment. His name is spelled correctly. And at this point in time, I will tell the court he does understand the charges, although I have filed a motion for competency. So I get that. That's with a grain of salt. So, but we're going to waive on his behalf, waive arraignment.
Okay. All right, the court will find that Mr. West has waived the formal requirements of arraignment, that his name is spelled correctly in the indictment. The court will enter his plea of not guilty into the record. The court will set this matter for pretrial hearing. Mr. Lowe, you said you have filed the motion for competency evaluation.
I filed the motion for competency and also notice of insanity defense. So I guess we need an expert for both of those matters.
All right, we'll take those. Sanity will take up to pretrial hearing. The motion for mental health evaluation, competency evaluation, I'll take up before that hearing. Did you file an affidavit supporting that motion with your specific interactions and basis for the motion?
Not in the form of the affidavit. In the motion, I state that Mr. West he's actually been found incompetent before in a case in El Paso. He's been institutionalized at least 3 times for mental illness. He's been diagnosed with bipolar disorder, schizophrenia, and depression. I think he's been handled here before, and that's been an issue before in this court. So, but I did not file an affidavit. That matter that's stated in the motion.
Okay, all right, then I'll take that motion up before the pretrial hearing. We'll take the competency issue up first, and then we'll deal with the insanity motion.
That's all.
All right, let's set this for hearing. Are you available on either June 1st or June 13th, Mr. Lowe?
June the 13th would be better, Your Honor.
All right, court sets Mr. West for pretrial hearing on June 13th at 1:30.
Thank you, Your Honor. That's all I had to do.
Thank you, Mr. Lowe. Appreciate it. Thank you, Mr. West.
Thank you.
Mr. Stevens.
We'll be waiting on some more papers. They're going to send them.
You do know that for sure.
Yeah, that's what Tyler just said.
Okay. All right. Mr. Cooks, are you ready?
I am.
Okay, as soon as we get your client back up, you'll be on deck. Mr. Stevens, are y'all gonna be doing that paperwork today?
Yes.
Okay,
No, so Tyler said he's sending them.
okay.
I said, I'll come get it. I mean, you're back.
Deputy, we're working on it and we'll get it sent over. We're gonna send it. I didn't know who was gonna be there. So I told Stephanie to email it to yourself, Miss Burns, Miss Rachel, and possibly and to Patty, because I didn't know who was gonna be there. So we'll get it there as soon as it's there, and we'll get it taken care of.
Not a problem. I didn't see your text until I was sitting over here with my client. I saw your text. So anyway.
That's fine.
Thanks, Tyler.
Yes, sir.
Very good. Mr. Chris, when you're ready, I think your client is in here.
Good afternoon, Mr. Cooks. How are you, sir?
Good afternoon, Judge.
All right, you have Mr. Owens today, correct?
I do.
All right, this is cause number CR 22193, State versus Jordan Dion Patillo Owens. We're set for pretrial. Mr. Cooks, have you had access to the state's online discovery, and do you have any?
We did.
Go ahead.
We received the CDs and video from the state, just reviewing the continued review discovery and making the offer with my client. I just need more time so he can review that also.
Okay. Do you have any need for a contested motion setting?
Not at this time.
Okay, all right, the court's gonna find that there are no pretrial, contested pretrial motion issues, and the court will then set this for a docket call. And so, the policy of this court, Mr. Coates, is at docket call, that's when I would want to hear whether or not there's going to be a plea agreement or a request for a jury trial or a bench trial. So give you time between, pretrial, where we're trying to take care of any pretrial issues, discovery, contested issues, and then docket call when all those issues are put to bed, and it's just the determination of whether we're gonna have an agreement, agreed resolution, or what's for some type of trial. So I'm gonna go ahead and send these out for docket call. The dates I'm setting for right now are June 1st or June 13th. If you'll check one of those to see what day is better for you.
Judge, if we could do June 13th, that'd be perfect.
Okay, all right, court will set Mr. Owens then for a docket call on June 15th. And so if Mr. Owens is in jail, then the hearings will be at 1:30. If he makes bail, then his hearings will be moved to 9 a.m. We do all of our bail cases in the morning and our jail cases in the afternoon. So Mr. Owens, if you make bail, then you'll be reporting to the courthouse here in Canton at 9 o'clock on the 13th. Otherwise, we'll see you at 1:30. Okay,
All right, thank you, Judge.
thanks. Have a good day.
Then Mr. Cooks, when you're done with that, you guys will keep the yellow copy, we'll call the box.
Okay. Thanks.
Good, I know, good. Okay.
All right, Mr. Schmidt, who are you ready on? Would you like first?
Matthew Wood.
Matthew Virgil England, CR 21-356, CR 23-12. And this is a plea today, is that correct?
That's correct, Judge.
All right, I have a bunch of pleas today, but I do not have this one. So can you tell me what the terms of the plea are?
We have two, in CR 21-356, it's a state's motion to adjudicate. We're gonna plead true and exchange the state's recommending that Mr. England's guilt be adjudicated, that he be sentenced to 10 years PDC, that be suspended for a period of 10 years. And that he be ordered to pay the balance of the financial obligations associated with that case. Do you need those balances, Judge?
No.
Okay, in addition to that, he's going to submit himself to safety as a condition of community supervision. In CR 23-12, upon a plea of guilt, the state's recommending that Mr. England's guilt be deferred. He'd be placed on 10 years community supervision, assessed a 0 fine, $290 in court costs, $55 reimbursement fee. They've also agreed to take DA 2022-1184 and 1185 under section 1245 of the Texas Penal Code into consideration. With that case, he will also, as a condition, submit to safety, and those are going to run concurrently.
Just a moment. Okay, so I'll get this motion to adjudicate.
Say again?
I said, give me just one.
Oh, okay.
All right, Mr. England, sir, if you'll raise your right hand when placing your oath. Mr. England, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help me God.
Yes, sir.
All right, you can lower your hand. Your name is Matthew Virgil, is that correct?
Yes, sir.
Mr. England, you appeared before the court on April 2022. You pled guilty to the third-degree felony offense of assault of a public servant. The court heard a plea agreement that day, found that there was enough evidence to convict you. The court followed your plea agreement, deferred a finding of guilt, placed you on probation for 4 years, ordered you to pay fines and court costs. During your period of probation, the state has filed this motion to adjudicate and revoke. It appears that that was filed on October 11th, 2022. And in that motion, they have alleged what appears to be 9 separate counts of ways that you have violated your community supervision. Have you had enough time to review this with your attorney, Mr. Richard Schmidt?
Yes, sir.
Is there any questions that you have about this motion to adjudicate or any of the paperwork that you've read over and signed today that would consist of your plea agreements in this case?
No, sir.
All right, and Mr. Schmidt, does your client waive the formal reading of the state's motion to adjudicate?
We do, sir.
All right, and Mr. Schmidt, do you believe Mr. England to be competent to plea agreements in both his cases?
I do.
You explained to him his rights as they pertain to the motion to adjudicate and also the new case and the advantages and disadvantages of the deferred adjudication plea.
Yes, sir.
All right, you believe that he understands all those and he's making waivers intentionally, knowingly, voluntarily of important rights within that plea agreement.
Yes, sir.
And Mr. England, you are charged with an indictment on a second-degree felony offense of assault of a police officer or judge. And the range of punishment for that offense, if convicted and sentenced, would be not less than 2 years in prison or more than 20 years in prison, and a fine not to exceed $10,000. That full range of punishment.
Yes, sir.
You understand the plea agreement that you've got before the court is that you're asking the court to consider the evidence, defer a finding of guilt, place you on community supervision for 10 years on the assault of a peace officer charge, assess you court costs, reimbursement fees, dismiss unindicted DA cases, and as a condition of your community supervision, to have you attend the safety program, which is the substance abuse felony punishment facility. Do you understand that? Is that your agreement?
Yes, sir.
You understand that if the court goes along with your agreements today in your deferred case, the court, if the court later finds after a hearing that you have violated any of the terms and conditions of your community supervision, the court could do several things, including convict you of the offense, revoke your community supervision, and sentence you to prison up to the maximum 20 years in prison. Do you understand that?
Yes.
You understand that in the motion to adjudicate case, the plea agreement is that upon your plea of true, the state's asking the court to convict you today of assault of a public servant, sentence you to 10 years in prison, suspend that sentence, and place you on 10 years community supervision. In addition, you would have to pay the remainder of your previous fines and court costs and reimbursement fees. And you would also have to attend the felony punishment facility, and that these sentences would run concurrent or at the same time. Is that your understanding?
Yes, sir.
All right, that's what you're asking the court to approve in each case. Is that correct?
Yes, sir.
All right, so Mr. England, on your motion to adjudicate case, how do you plead to the 9 counts alleged? Was counts true or not true?
True.
Are you telling me that those are true because in fact, what is alleged is in fact true? You're not just saying that to get a certain plea agreement?
Yes.
And with regard to the indictment for assault of a peace officer, second degree felony, how do you plead to that offense? Guilty or not guilty?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes.
Has anyone threatened, force, or pressured you to plead true to your motion to adjudicate or guilty to your new charge?
No, sir.
All right, the court accepts the defendant's plea of true in CR 21-356 and his plea of guilt in CR 23-12. Court also takes judicial notice of the defendant's judicial confession Mr. Schmidt, any objection to the defendant's waiver of rights, motion to adjudicate, and the stipulation of evidence states one?
No objection.
All right, both of those are admitted. Anything further from the state?
Judge, I have attempted to reach the sheriff's deputy that is the subject of the newer case. We've played basically phone tag. My understanding is that he's okay with what we're doing, but I haven't had a chance to actually talk to him about it. But my understanding is that he's supportive of our plea. Well, the messages I've gotten back and forth indicate he's okay, but I haven't gotten an actual talk to him to get him to fully understand what we're doing. He understands that this is actually, in my opinion, a harsher penalty on Mr. England than just sending to prison and just being done with it. That's my opinion. I hope the court sees the wisdom of what we're doing, giving him the opportunity to spend time in rehab. And if he's not successful, then we have the entire 20-year range to hold over his head and the first 10-year range, and we can stack. I hope that Mr. England understands that that's what we're doing, and it would be probably a lot easier for him to just take pen time and be done with it. But this is the deal we worked out. He would like to seek an opportunity to have rehab, and we would like to provide him with that, with the enormous hammer that is hanging over his head.
Thank you, Mr. White. Anything further from the defense, Mr. Schmidt?
No, Judge, we would concur with the state's position.
Mr. Woodwhite, can you give me the facts to support the plea in CR 23-12?
Yes, Judge. On the date in the question, the defendant is he has parked his vehicle in front of a house that is not his. The homeowner calls the police because he is very intoxicated. Sheriff's office gets him and detains him to talk to the homeowner. When they return, he is headbutting the window of the squad car. They go to restrain him, and basically he headbutts the sheriff's deputy in the back of the head, not causing injury, but causing pain. They restrain him and take him to the jail, where he is put in the restraint chair because he is so intoxicated.
Objections, Mr. Schmidt?
No, sir.
All right, so Mr. England, before we go any further, I want to hear from you as to why I should approve another shot at probation when I've already given you a shot. I want to hear from you why you're worthy of this option.
So I just want a chance to get help and then get back to my family.
And so you think that going to rehab, you think that's what it's gonna take?
Yes, sir.
So if I send you down to rehab, you're not gonna go down there and waste my time and your time, are you?
No, sir.
You're gonna go down there with the intention of actually learning how to control your addiction.
Yes, sir.
You understand that there's not going to be a fix-all. You get down there. You understand that?
Yes, sir.
You understand everything that Mr. Woodwhite said, that Mr. Schmidt concurred with, that you have a serious, he called it a hammer. You've got a serious situation that you got to deal with for the next at least 10 years. You understand that?
Yes, sir.
Looking at a potential 20-year incarceration. If you violate that, that means if you get to 9 years and 11 months and 29 days, and you decide you're going to drink and drive or commit any other violation of your community supervision, you could be revoked and sentenced to prison up to 20 years in 10 years. Understand that?
Yes.
Judge, not to interrupt you, I'd like to point out that it would be 30 years because the state at that point would ask to stack these.
Okay, 20 years, 30 years. Court would have that ability. You understand that, Mr. England?
Yes, sir.
Understanding all that, you sure that you want to go for it?
Yes, sir.
All right, then, based on the evidence presented to the court today, the court finds that Matthew Virgil England has violated his community supervision in CR 21-356. Upon the corresponding of the violations to be true, the court will follow the plea agreement in that case, or adjudicates the guilt of Mr. England convicts him of the third-degree felony offense of assault of a public servant. Court assesses that sentence at 10 years confinement in the Texas Department of Criminal Justice. Court will suspend that sentence pursuant to the plea agreement, place Mr. England on 10 years community supervision, order him to pay the balance of his financial obligations, and the court will require that Mr. England participate and complete the substance abuse felony punishment facility as a condition of his community supervision. And CR 23-12, court finds that there is sufficient evidence to convict Mr. England of assault of a peace officer. The court will follow the plea agreement between the defense and the state. Court defers the finding of guilt, places Mr. England on 10 years community supervision, orders him to pay a $290 court cost, $55 in reimbursement fees. Court takes into consideration 1245 DA 2022-1184 and -1185. And there's no restitution involved in the new charge. Is that correct, Mr. Schmidt?
That's correct, Judge. It's all piled into the motion to adjudicate.
All right, and then, okay, that's including the reimbursement fees for court appointed counsel.
Yes, sir. It's my understanding. I think that the amount would encompass unpaid from the prior plea as well as the additional 500. It's like 1,400 something.
Very well. All right, Mr. England, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. You'll be taken in custody today while you await a bed at safe being. So ball's in your court now. We'll see what you decide to do with it. If it's something good, I'll have you step over with Deputy Completion so that you can be fingerprinted and the probation officers will give you more information.
Okay. This one? Right here. Okay, sorry. Yes.
Who's next, Mr. Schmidt?
Misty Reeves, arraignment.
Misty Ann Reeves, CR 2369. Ms. Reeves is set for arraignment. Go ahead, Mr. Schmidt.
Judge, Ms. Reeves' name spelled correctly on the document. She understands what she's charged with. We'll wait for formal reading in her plea of not guilty as per pretrial setting.
All right, court will find that Ms. Reeves has waived the formal requirements of arraignment. Court sets, and the court enters Ms. Reeves' plea of not guilty into the record. The court sets this matter for pretrial hearing on June 27th. 1:30 if Ms. Reeves is in jail, 9 a.m. if she's on bail.
So. That's what I was trying to do. Okay. So try to get. Thursday. See if we can't get it. What I'll do is, I'll get one Thursday. Pay attention. So, if we can do the probation, it's up. I'll be here on Thursday.
Who do you like next?
Warren Pruitt.
Warren Clay Pruitt, CR 22-45. We're set for status on competency.
Conversation. Judge, we're here on status of competency, which stated, Mr. Pruitt is still awaiting a bed. However, as we spoke last time, Mr. Pruitt's condition is vastly improved. I think that at this point in time, we'll file a formal motion to reconsider competency so that we can move forward. But I think that we're ready to go forward without the necessity for a commitment for restoration.
Remind me, was Mr. Pruitt placed on mental health meds while he was awaiting a bed?
He has been judged, and they, so far as I can tell, they've done wonders for him.
Okay, so do we need to have him reevaluated by Dr. Ingram?
I would appreciate that, yes, so that we can clear it up.
All right, so let's set Mr. Pruitt then for another status on competency. We'll set that for June 27th, and in the meantime, I'll ask Dr. Ingram to come visit Mr. Pruitt again. And if he's of the opinion that he's competent, then it'll.
Do you understand? Why we're doing what we're doing? Okay. So I'll take it. Does I have O'Brien Colquitt on the docket? I believe that he's still in, we expected him from Louisiana. I don't know that he's in our custody.
What was his name again?
Colquette Colquitt. O'Brien.
Yes, looks like Ms. Abraham verified he was in Morehouse Parish Jail yesterday. So let's just reset him for arraignment and status of custody on June 27th. Who do you like next?
Joseph Cronin.
Joseph Paul Cronin, CR 22-322 for docket call.
Yeah, Judge, we were on a previous docket call and Mr. Cronin had some issues that prevented his appearance in court, hence his custody status. We received an offer from the state that I need to relay to him. I'd ask for an additional docket call in hopes that we have a resolution for the court. Okay.
Do you need an extended period of time or like a couple of weeks?
A couple of weeks to be fine, Judge.
All right, you want to shoot for Tuesday, May 9th?
Yes, sir.
All right, court sets Mr. Cronin for docket call on Tuesday, May 9th.
Mondays. I'm not your father, but yeah. Okay. I'm sorry. That's okay. Yeah, I'll bring it to you.
Next.
Molina. No, I've got Mr. Horton.
Horton, John David Horton, 2021-90, CR 21-126, CR 21-127. Show that we're on status, an objection to competency.
Judge, I think ultimately I've been in contact with the state quite a bit. I did meet with Mr. Horton a couple of weeks ago and spoke with him. We've got a multitude of issues pertaining to mental health that relate back to his condition prior to restoration. The state has made an offer, which at this point in time, I have not conveyed to Mr. Horton. And ultimately, I need to meet with him on Monday in detail so that I can determine whether or not a course of action needs to be taken. So I would ask the court to hold open the competency issue at this point in time. However, depending on the fruits of our conversations, we may be able to switch gears pretty quickly. And I know Mr. Horton wants to, so that's the goal.
What do you think about setting it for the evidentiary docket on May 30th? That way, if there is an objection to competency, we can have Dr. Ingram, I believe, here, and we could.
Is that the next evidentiary docket other than Thursday?
Thursday, yes, sir.
Okay. May 30th, I guess we'll have to work.
All right, court will set Mr. Horton then for status on competency on May 30th.
Anybody else?
Mr. Jarvis.
Good afternoon, Mr. Jarvis.
Good afternoon, Judge.
All right, remind me who your client is, Mr. Jarvis.
Henry Morales Arias.
Sorry. Yeah, he's not appearing on my docket. Neither were you. That's why I was kind of
And
confused.
Judge, I talked to your staff this morning. It was a case where I filed a motion to substitute several weeks ago. I think you signed it this morning. So they moved him up to today on this jail call.
That's right. Okay, it was sent Thursday. All right, give me just 1 second. Do you have that cause number handy, Mr. Jarvis?
CR 23-00029.
Thank you, sir. All right, this is cause number CR 23-29, State versus Henry Ariel Barrios Morales. And it appears that we were set for pretrial on Thursday, April 27th at 1:30. We've reset that to today. Go ahead, Mr. Jarvis. Any contested pretrial motions or issues?
I don't believe so, Judge. I've talked to the prosecutor. I have the written discovery. I'm waiting on the videos. I'm gonna go by and pick those up today. Once I get those, I think we'll be ready to proceed forward. And I've talked to the state a little bit. We have a couple of weeks. Hopefully we can get something worked out.
Right, then what we'll do is we'll set you haven't reviewed any of the videos yet, correct?
I have not, Judge. We have gone over the written report. If we could have till maybe May 30th, that'd give us plenty of time to hopefully get something worked out. Maybe one more hearing and we'll be finished.
What about May 30th is my evidentiary docket, so what about June 1st? June 1st or June 13th?
June 1st should be fine, Judge.
Okay, all right, then we'll set Mr. Morales then for pretrial hearing on June 1st at 1:30, so long as he's in custody. If he's on bail, then it'll be at 9 AM. And then if
Yes,
we
sir.
reach a resolution between now and then, I do have other docket settings, May 9th, 11th, 25th. If you want it sooner, then I can set it sooner.
Yes, sir.
All right, Mr. Morales, we'll see you back on June 1st.
Thank you, Judge.
You're welcome, sir.
Can I be excused?
Yes, thank you, Mr. Jarvis. Appreciate you.
Thank you, Judge.
Mr. Law. All right.
All right, Mr. White, are you ready on Mr. Duran?
Yes, sir, I am.
All right, come on, Mr. Duran. This is cause number CR 2265, State versus Oscar Malenal. All right. And Mr. Duran, sir, if you will, raise your right hand. I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, thanks. So you can lower your hand. All right, Mr. White, it appears that we're here today on the state's motion to adjudicate guilt and that there is an agreement in this case. It looks like Mr. Duran would be pleading true to all counts of the state's motion in exchange for the state's recommendation that his guilt be adjudicated, supervision be revoked, punishment be assessed under 1244A at 60 days confinement in the county jail. He would receive credit for 3 days of time served. He would still have to serve the remainder of his time and pay the balance of his financial obligations, which is $70 for court costs and $5 in a restitution. Is that correct, Mr. White?
Your Honor, we are going to plead true to counts three through how many ever are left. The first two, we're not gonna, I think the state's either gonna abandon or we're not gonna enter a plea on those.
Yeah, state's comfortable abandoning 1 and 2.
All right, Mr. Duran. You heard what I just stated to Mr. White regarding the plea agreement. Is that your understanding of your plea agreement today?
Yes, Your Honor.
All right, Mr. Duran, have you had enough time to talk with Mr. White, your attorney, about your case so that you don't have any more questions?
Yes, sir.
Is there anything about the paperwork that you read over and signed today? Do you have any questions about the paperwork that you've read and signed today?
Oh, no, sir.
And where your name appears, is that your true and correct signature, and you're only signing that once you're confident that you know what you're signing and you understand everything?
Yes, sir.
Okay. And Mr. Duran, have you had an opportunity to read over that motion to adjudicate and revoke with Mr. White?
Yes, move on.
Your Honor, just so you know, there's a little bit of a delay.
Okay.
And so you're coming through to us, but it's just a little bit delayed. So that's why he's catching sometimes about every third word.
Okay, I understand. If that happens, if that continues, just let me know.
Yes, sir.
We'll try to figure that out.
But I think where we were was, we've gone over the motion to adjudicate. He's aware of what the allegations were, and we still want to go forward with entering the plea.
Okay. All right, Mr. Duran, you appeared before the court on July 19th, 2022. You pled guilty to the second-degree felony offense of possession of a controlled substance, penalty group 2, between 4 grams and 400 grams. The court deferred a finding of guilt on that matter that day, placed you on community supervision for a period of 2 years, and also ordered you to pay a $1,000 fine. It was during your period of community supervision that the state has filed its motion to adjudicate and revoke. And in their motion, they have alleged what appears to be 10 separate counts. I understand that the state is abandoning count 1 and 2. So Mr. Duran, as to counts 3 through 10, how do you plead? Are those counts true or not true?
True.
And Mr. Duran, are you telling me that counts 3 through 10 are true because in fact, what is alleged is true? You're not just saying that to get a certain plea agreement, is that right?
Yes, sir.
All right. And Mr. Duran, has anyone threatened, forced, or pressured you to plead true to any of these counts today?
No, sir.
All right. Court will accept the defendant's plea of true to counts 3 through 10. Court will take judicial notice of his judicial confession. Mr. White, any objection to the defendant's waiver of rights and plea of true?
No, sir. No objection.
Court will admit the defendant's waiver of rights and plea of true. Anything further from the state?
No, Your Honor.
Anything further from the defense, Mr. White?
No, sir, but I will note that I have explained to Mr. Duran that this, while he's doing county jail time, which is true, that this is a felony conviction. And now he's a convicted felon, and that everything that kind of goes with that from the standpoint of loss of civil rights and those sort of things have now kicked in, once the court accepts it. And just because it's a punishment here, at the jail doesn't mean that it's any different than any other felony.
Mr. Duran, do you understand what Mr. White just said?
Oh, yes, sir.
You understand that after you serve your time, then you're going to be prohibited from possessing a firearm within 5 years from your period of release at any place other than your home after that 5 years. Do you understand that?
Yes, sir.
So you're going to have firearm prohibitions as a felon. You understand that?
Yes, sir.
So counsel, so it's my understanding he was originally charged with a second degree. And so the charge today is going to be
We were planning on proceeding. I was just looking at the paperwork, Judge. I don't think it's very clear. If we need to print off another judgment to make it more clear, we're proceeding on a lesser included state jail PG2. Less than 1 gram is what Mr. White's in my agreement was. I don't know that the paperwork very accurately describes that.
Yeah, I would agree on the judgment where it says offense for which defendant convicted, that there needs to say state jail felony in order to implicate 1244A possibilities. Otherwise,
I was just noticing that, Judge. We'll get that corrected and sent over to the court.
okay. All right, then based on the evidence presented to the court finds that Mr. Duran has violated the terms and conditions of his community supervision. Court finds counts 3 through 10 to be true. On the basis of that finding, the court will follow the plea agreement reached between Mr. Duran and the state. The court convicts him of the lesser included offense of possession of a controlled substance, penalty group 2, less than 1 gram, a state jail felony. Court will assess his sentence pursuant to plea agreement and also 1244A at 60 days confinement in the Van Zandt County Jail upon revoking community supervision. Court will award Mr. Duran 3 days credit towards his sentence for the time that he has spent in jail on this cause. Order him to serve the remaining time. Court will order him also to pay the balance of his financial obligations, which includes a $70 court cost and $5 restitution. Mr. Duran, you're hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of the sentence. And have you step over with the deputy to be fingerprinted.
All right, that's all I have today. Mavis.
Yes, and so Mr. White, we're going to amend the front page of the judgment to reflect
That's
that.
absolutely right. I was gonna broach that with Mr. White, but everybody caught it before we had to talk about it, so.
Okay, good. All right, so we'll get that changed.
Mr. White, Bill Patrick is expecting you. If you'll just check in with the ladies at the front.
All right, Mr. Stevens, Mr. Waddle.
Yes, sir.
This is cause number CR 21-317, State of Texas versus Joseph Dan Aguado. Mr. Aguado, how are you today?
All right.
Okay, and Mr. Aguado, I need to ask you some questions, but before I do so, I have to place you under oath. That means I want to ask you to swear to tell the truth. Can you do that for me?
Yeah.
Okay, and Mr. Aguado, can you just raise your right hand for me, sir? Mr. Aguado, do you swear that the testimony you give to the court today, that it will be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
All right, thank you. Mr. Aguado, you can put your hand down. All right, Mr. Aguado, is your name Joseph Dan Aguado?
Yeah.
And Mr. Aguado, you are a United States citizen, is that right?
Yeah.
And do you read, write, and speak English?
Yeah.
And Mr. Aguado, I know that you have been diagnosed with some mental health conditions in your past. And in fact, in this case, you've been hospitalized due to competency and you've been given a treatment plan and you're back in custody being returned from the state hospital. Do you feel like you understand everything that's going on in the case today?
Yeah.
And your attorney, can you tell me what your attorney's name is?
Bill Stevens.
And Mr. Stevens has been your attorney for quite some time now. Do you feel like you've been able to talk to Mr. Stevens and have all of your legal questions answered?
Yeah.
And Mr. Aguado, is there anything about the paperwork and the things that you and Mr. Stevens have talked about today that you don't understand?
No.
And are you pleased with Mr. Stevens as your lawyer?
Yeah.
Has he done a good job for you?
Yeah.
Okay, Mr. Stevens, do you believe Mr. Aguado to be competent today, considering the lengthy amount of time that you and the state and the courts have been working with Mr. Aguado and his mental health?
Yes, sir, I do. And also, just to let the court know, I visited with him this past Friday in anticipation of today's court, just to make sure that, you know, he knew what was going on, and he absolutely did. And when we talked this morning earlier, signing the papers, he knew who I was, he knew what was going on and everything required of me. So, yes, sir, I do believe he's competent this time. He's a man of few words. So, but that's him.
Okay, and Mr. Stevens, you've explained to Mr. Aguado his charge, this plea agreement, and do you believe that he is entering into this plea agreement intentionally, knowingly, and voluntarily after being advised of his rights?
Yes, sir, I absolutely do.
Okay, all right, Mr. Aguado, there's a few things I've got to explain to you. One of them is that you've been charged with injury to an elderly individual, but today it looks like the agreement that the state's making with you is that that charge would be reduced to an attempted injury to an elderly individual, and that is a state jail felony, Mr. Aguado, and that carries a range of punishment. Usually that's a prison sentence, but in this case, the state is asking that you be prosecuted under a misdemeanor provision of the law, in which they're asking that you be given time served, which is 365 days in jail. You would get credit for all of the time that you have spent in jail. You would be convicted of that offense, attempted injury to an elderly individual, and you would be ordered to pay court costs and some reimbursement fees, and then the state would be dismissing their other cases. Do you understand that plea agreement and what's going on today?
Yeah.
All right, so Mr. Aguado, understanding the plea agreement, understanding the range of punishment, I would ask you, Mr. Aguado, can you tell me whether or not you are guilty or not guilty of attempted injury to an elderly individual?
Guilty.
Okay, and are you telling me that, Mr. Aguado, because the things that you did would make you guilty?
No. Yes.
Okay. Yeah, I know. Okay, so you understand that you're pleading guilty for what you've been accused of. You're not just saying that you're guilty so that you can go home, right?
Yeah.
Okay. All right, Mr. Stevens, is there any objection to the evidence supporting the plea?
No, sir.
All right, State's Exhibit 1 is admitted. Court takes judicial notice and accepts the defendant's plea of guilt at this time. Mr. Woodwhite, can you give me the evidence to support the plea on behalf of Mr. Aguado?
Yes, Judge. On the date in question, the defendant brings a dog into his grandmother's house, who is the victim of this charge. She tells him to take the dog back outside because the dog is barking, and he becomes upset. She says she's going to call the police, and he attempts to snatch the phone out of her hand. She runs to her bedroom and he follows. She tries to close the door and he pushes his way into the room, which she says the door hits her and hurts her. And then he attempts to close the door. She places her foot and leg in the way, and he closes the door on her foot, and she says that hurts. She yells for help, and he says that he's leaving and leaves, and the named victim's sister calls the police.
Thank you, Mr. Woodwhite. Mr. Stevens, any objection to that summary?
No objection, John.
All right, then based on the evidence presented, the court finds that there is enough evidence to convict Mr. Well, let me ask Mr. Woodwhite, and the victim in this case is an elderly individual, is that correct?
That is correct, Your Honor. I'm sorry. Yes, she is 72 years old at the time of offense.
All right, thank you, sir. All right, then based on the evidence presented, the court finds that there is sufficient evidence to convict Mr. Joseph Dan Aguado of attempted injury of an elderly individual. The court will follow a plea agreement in this case. The court hereby convicts him of that attempted injury to an elderly individual. The court will assess punishment under section 1244B. of the Texas Penal Code at 1 year confinement in the county jail. Court gives Mr. Aguado 1 year credit for time served. Orders him to pay his court costs of $270, reimbursement fees of $1,020. The court dismisses DA 2021-675 and 2022-85 under section 1245 of the Texas Penal Code. All right, Mr. Aguado, you hereby remanded to the custody of the sheriff so he can carry out the terms and the conditions of the sentence. Mr. Aguado, I do want to tell you that it's very important that you stay on your medication so that you don't end up back here in the jail. Okay, it's very important that you take that medication so that you'll know how to behave, how to act, how to respect your grandmother, how to respect everyone that you deal with, so that you can be at home and not be here in the jail. Okay, can you do that for us?
Yeah.
All right, thank you, sir. All right, Mr. Guado, I want you to step over with the deputy. She's going to take your fingerprint, and then they're going to take that paperwork and they're going to process you out of the jail soon.
Thank you, Judge. I'll be excused.
Yes, thank you, Mr. Stevens. Hey, I do want to commend you for your work on this case. I appreciate you doing what you did for Mr. Aguado. I know that this has been a challenging case. I want to commend both the state and the defense for working on this and coming up with a resolution that it's in Mr. Aguado's best interest. I know that his the victim in this case, grandmother, is in constant contact with the court, worried about Mr. Aguado, and she wants him home. So I think that justice has been done today in this case for both the defendant, the victim, the state, and couldn't have done it without y'all. So I appreciate your help.
Yes, sir. No problem at all. Thank you, Judge.
Thanks, sir.
Thank you, Mr. Stevens. Mr. Roboto, go with my sergeant, okay? Thank you, Sarge. Your Honor, I believe we are back to Mr. Schmidt, who is visiting with one of his clients right now.
Okay, is Mr. Okay, let's go ahead and call Corey James Butler. And it doesn't have anything to do with you, Deputy McClay. I think he's still in federal custody. State, do you have any updates for the court on Mr. Corey Butler? I don't know, Mr. Trainer. Or I don't see one saying.
Judge, this is the one that he is, according to Mr. Trainer, which I have no real reason to doubt. He is in federal custody. He has a sealed plea deal that he is going to take. I believe, I don't know this, but I believe he is cooperating or something of that nature. So they have sealed his deal, and Mr. Trainer is going to get us some evidence of that deal. And once that deal actually goes through, the state does intend likely to dismiss this charge because we believe he will be in federal penitentiary under that deal is I believe our understanding, but we are just waiting for the feds to actually formalize that plea deal. But I've received nothing regarding that he has done that or anything of that nature.
For some reason, I was recollecting that he was supposed to have effectuated his federal deal by now. For some reason, I was thinking we said that specifically a week or two.
I believe Mr. Trainer relayed to the court that he believed it was going to be done by this date, but I have not received anything from either the federal, the U.S. attorneys or Mr. Trainer, who I believe he has relayed to the court previously that he does not represent Mr. Butler on the federal case. He was basically contacted to represent him on this case in order to facilitate the federal case going forward. That's the information that the state has at this point regarding Mr. Butler.
All right, then let's just set him out for another status. Let's set it a little further. We'll just set it July 25th.
And I will reach out to Mr. Trainer as well and see if I can't get an update for the court, Your Honor.
Thank you, sir. You're ready. Who are you ready on, sir?
James Hancock.
All right, Mr. Hancock, morning, sir. This is James Lee Hancock Jr., CR 22354. Show that we're set for plea today. Is that the case?
That's correct.
All right, Mr. Hancock, if you'll raise your right hand, sir, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help me God?
Yes, sir.
All right, Nate, you can lower your hand. Your name is James Lee Hancock Jr., is that right?
Yes.
And Mr. Hancock, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with a mental condition?
No.
You're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt as your attorney?
Yes, sir.
You feel like you've had enough time to talk with him about your case, and you've had all your legal questions answered?
Yes.
You've signed paperwork here today. Is that your true and correct signature that you affixed to the paperwork, and do you understand everything you've read and signed?
Yes.
Mr. Schmidt, do you believe Mr. Hancock to be competent today?
I do, Judge.
You've explained to him his rights as they pertain to this case,
I have.
and you believe that he is entering into this intentionally, knowingly, voluntarily regarding the waiver of the rights he's making herein.
Yes, sir.
All right, Mr. Hancock, you are charged by indictment with a first-degree felony offense, manufacture or delivery of a controlled substance, penalty group 1, greater than or equal to 200 grams, but less than 400 grams. That carries a range of punishment of not less than 5 years in prison or more than 99 years for life in prison, and also a fine which cannot exceed $10,000. I see the plea agreement in your case is that you would plead guilty to that charge. The state would recommend to the court that your sentence be assessed today at 20 years confinement in TDC with a $1,000 fine, plus court costs, restitution, and reimbursement fees, and that you would get 274 days credit towards that sentence for the time that you've already spent in jail. Is that your understanding of the plea agreement?
Yes.
All right, Mr. Hancock, then understanding the plea agreement, understanding the range of punishment, how do you plead to that charge?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes.
Has anyone threatened, forced, or pressured you to plead guilty today?
Oh.
The court accepts the defendant's plea of guilt. Mr. Schmidt, any objection to states 1?
No objection.
States 1 is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Your Honor, I do believe, if I'm recalling correctly, that the indictment contains I'm sorry, it didn't. We had a Brooks notice. But you will notice on the face of the judgment, the state is abandoning the enhancement paragraphs and proceeding just on the first degree felony with no enhancement paragraph.
All right, thanks. I'm sorry, thank you. All right, Mr. Schmidt, anything further from the defense?
Nothing further, Judge.
All right, court's going to review the evidence briefly. All right, the court has reviewed the evidence. The court finds that there is sufficient evidence to convict Mr. Hancock of this offense. The court will follow the plea agreement reached with the state. Court hereby convicts James Lee Hancock Jr. of manufacturing delivery of controlled substance penalty 1, greater than or equal to 200 grams, less than 400 grams, a first degree felony. The court assesses punishment at 20 years confinement in the Texas Department of Criminal Justice, orders him to pay a $1,000 fine, $180 restitution, $20 reimbursement fees, and $290 court costs. Court awards Mr. Hancock 274 days credit for the time that he has spent in jail on this charge. Mr. Hancock, you're hereby remanded to the custody of the sheriff so he can carry out terms and conditions of the sentence. Have you step over with the deputy. What else, Mr. Schmidt?
Jeremy Ward.
Jeremy Ron Ward, CR 18384, CR 18385. Motions to revoke. Go ahead, Mr. Schmidt.
Yes, sir. I was recently appointed to Mr. Ward's cases. I met with him for the first time on Monday. I'm going to need some additional time and ask that these be reset.
All right, court will set Mr. Ward for. We'll set him for motion to revoke hearing on June 27th. We'll go ahead and set him for contested hearing 2 days after that if there's no resolution on the 29th.
Yes, sir.
Mr. Schmidt, let me think about that for a second. Do we need the 27th setting? If I set you on the 29th, does that give you sufficient time to work it out? Play it that day. I don't need to look yet.
Yeah, I think one setting would be sufficient. Will either do it or I'll beg for more time.
Let's do the 29th and you don't beg for more time.
Yes, sir. I probably still will.
All right, so I'm gonna correct the record. We're gonna set Mr. Ward for hearing on 6/29.
Thank you. Judge, also I have a couple more, but I have an Ivan Molina Hernandez on the docket that I think he was set for an arraignment today. He is not in custody. I wanted to clear that up because I know I filed a 90-day writ that the court signed on the 21st. So he was released from custody probably on the 21st. I can tell you that Mr. Molina Hernandez does not speak English. And I had met with him through an interpreter some time back. So there's a high likelihood that if he wasn't here this morning, he had no idea that he needed to be here. And I'd ask the court if the court's called his name or was gonna to give me an opportunity to see if I can't clear that up and get him in because I'm certain he doesn't know.
Yes, the court did call his name this morning and I declared nice eye and alias KPS. Let me see what notice we sent, where we sent it. You know him to be a resident of Florida.
He is a Cuban national, judge, so I would suspect that looks correct. In addition to that, I believe that based on my talks with him that he should have, if he didn't have an ICE hold. So I don't know if he was taken into custody by Immigration Services or not. I have not heard from him since the writ.
When did you say he was released on his writ?
It should have been, well, I mean, the court granted the writ on April 21st. And he was out of, I think that was on a Friday, so he was out of custody by Monday. The following Monday, which was this past, maybe yesterday.
This notice would have been mailed about a month before that, if his address is still correct there.
Perhaps, but he wasn't there.
Sure, so I guess find out what you can and then let the court know, and if he's obviously in custody or if you can get him in, then the court will reconsider the bond forfeiture in these cases.
Thank you, Judge. James. I've got James Booker. We're here on a writ requesting a bond reduction.
All right, this is written WR 23-22. You know, you're gonna be calling Mr. Booker today.
I will, Judge.
All right, Mr. Booker, you're gonna be called for the limited purposes of your writ seeking bail reduction. Go raise your right hand, sir. I'm gonna place you under oath. Mr. Booker, do you swear that the testimony you give to the court will be the truth, the whole truth, nothing but the truth? So help you God?
Yes, sir.
All right, you put your hand down. Just speak up loudly and clearly for me so I can hear you. So my court reporter can take down what you have to say, okay? All right, go ahead.
Thank you. State your name for the record. James Booker. And Mr. Booker, are you a resident of Van Zandt County? Yes, sir. Where do you currently live other than Van Zandt County Jail? Wills Point. All right, do you have an address in Wills Point? 235 Main Street, Wills Point, 65169. And have you lived there most of your life? Yes, sir. And you were arrested for a narcotics related offense on March the 5th, correct? Yes. And your bond was set by the court or a magistrate at $25,000 cash or surety, correct? Yes. Now, you've been in, close to 45 days. Have you made attempts to come up with funds through yourself or your family to post a $25,000 bond? Yes. And those efforts have been unsuccessful, correct? Yes. Now, you're asking the court to reduce your bond to an amount that you could make so that you can be out of custody pending the resolution of your case. Can you tell the court how much money at this point you think you can come up with through your family to post a bond? $10,000 bond would probably come up for that. So you think your people can raise enough money to post a $10,000 bid? Now, if the judge were to grant your request and you were to bond out, where would you reside? In Wills Point? And do you have transportation back and forth to court in the event this case gets indicted? Yes. And do you have any issues that would prevent you from making it to court once a court date is set? And do you have a job? Yes. And where would you work if you were your Mayday? Where at? Mayday, Thorough, Texas, on Airport Road. Okay, and what do you do for them?
I'm sorry, can you repeat that? We couldn't hear that.
Oh, Mayday.
I heard you say something Terrell, Texas, Airport Road. That's all we heard.
Oh, Mayday.
Maydex.
And you do metal work for them? Yeah. Okay. And is that job still available if you were out on bond? Yeah. Okay. Is there any reason to believe that you would not show up to court while on bond? No. Have you had issues with that in the past that you know of, other than maybe an accidental miss? No. No. Okay. We'll pass the witness.
State any questions of Mr. Booker?
Judge, Mr. Booker, when were you arrested?
March 5th.
Okay, so you've been in about a month and a half. That's all right. And you're gonna live in Wills Point, is that what you said? Do you own property there?
My parents.
You live with your parents? Do you have a vehicle?
Yes.
Is it paid for?
Yes.
Okay, so what's the value of your vehicle, sir?
It's like 97.
Okay. Judge Stay has no further questions.
All right. Anything further, Mr. Schmidt?
Nothing further, Joe. I just would note for the court that as far as I can tell, this is the only charge that Mr. Booker is in custody for. And it is a narcotics related offense. The likelihood that the state will have this matter indicted waiting on lapse by 90 is pretty slim. We'd ask the court to grant the reduction in the event that the state doesn't have him indicted in 90, we'll be back on another writ. But under the circumstances, he is local. I've got history with Mr. Booker, so we'd ask the court to grant that reduction.
Thank you.
Was that state or thank you?
State.
Oh. Judge, state's not overly opposed to Mr. Booker receiving the bond in question. I think that probably the value of his vehicle, as he's not asking for a PR bond, if the court wants to set him $10,000 bond. I think Mr. Schmidt's not wrong. It's unlikely we'll get a lab back within the next month and a half. As long as he's going to remain in this county with whatever conditions the court sees fit to place on him, state's not opposed to granting him the requested bond of $10,000.
What's the alleged charge? I heard possession of controlled substance. What level?
It's penalty group, it's manufactured delivery, controlled substance penalty group 1, between 1 and 4 grams of second degree felony is what he was arrested for.
All right, if there's nothing further, the court's going to take that under advisement, and I'll issue a ruling at the conclusion of the docket.
Thank you.
Have anyone else, Mr. Schmidt?
Cornelio Reyes.
Mr. Reyes? CR 22-114. Is this a motion to reduce bail, I believe?
It is, Judge. We previously announced ready for trial with Mr. Reyes. Also, the court will recall he had prior counsel, I believe it was Mr. Ashmore, and they announced ready for trial. We put him back on the docket for my purposes, but he is on the revolving jury trial docket. We would ask to take some testimony to proceed, requesting a bond reduction pending jury trial.
All right, Mr. Reyes, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, lower your hand, speak up loudly and clearly for me. Go ahead, Mr. Schmidt.
Mr. Reyes, you're currently being held on a $40,000 bond, is that correct?
Yes, sir.
Now, previously, how long, do you recall at this point, how long you've been in custody with Pennington County Sheriff's Office?
I was picked up and agreement on September 7th, I believe. Sorry, sir.
And I'm sorry, Mr. Schmidt, I can't hear anybody saying it all.
All right. Yeah, speak up a little bit so we can hear you. So you've been in custody this time, how long?
Since September 7th.
September 7th. Previous to that, you were on bond, is that correct?
Yes, sir.
And at one point in time or another, you failed to appear before this judge on a scheduled court date, is that correct?
Yes, sir.
And you had a hearing or you had an opportunity with Mr. Ashmore to address your failure to appear with the court. And the judge subsequently revoked your bond, correct?
Yes, sir.
At the time, you had provided, or you were under the misconception that the doctor's note that you provided the court or your medical reasoning was sufficient to excuse you, but you realized that that was incorrect, right?
Yes, sir.
Now, you've been sitting here for a while since then, and we've had several opportunities to talk about your case, right?
Yes, sir.
And after discussing your case and discussing the merits with the state, you've determined that you want your jury trial rights.
Yes, sir.
And we're on that jury trial docket. At the end of the day, on a $40,000 bond, are you capable of posting that bond?
Not 40,000.
And you've been in for a while. Obviously, if you could have posted that, you would have. Is that right?
Yes, sir.
And are you asking for the court to reduce your bond today?
Yes, sir.
And can you tell the court how much that you could make?
$10,000.
Maybe 10,000?
Yes, sir.
And you have a bondsman that you had paid previously, and you have some indication from that bondsman that he's willing to work with you if the bond is reduced, correct?
Yes, sir.
And what's that bondsman? Do you recall or
East Texas bail bonds, Justin.
East Texas bail bond? And prior to missing your court date, which resulted in your bond being revoked based on your medical issue, had you missed any court dates prior to that?
No, sir.
And had you been in contact with your attorney and in contact with pretrial release office?
Yes, sir.
So other than that one event, you had been on track with the court's orders to be in court and to follow your pretrial.
Yes, sir.
And if the judge were to agree or to grant your request to reduce your bond to 10,000 and you post the bond, you understand that you're still on the jury job docket correct? Yes, sir. And you would have to appear each reset until your case was called for trial, and reset your case and keep doing that until ultimately your case goes to trial. Understand that? Yes, sir. And are you telling the court that based on your experience and your prior issues that you fully understand at this point that unless you get written permission not to appear, you cannot assume that you have an excuse not to be in court, correct? Yes, sir. We'll pass the witness, Judge.
State, any questions?
Judge, I would ask that the court take judicial notice of the court's file.
Or we'll take judicial notice of the file in CR 22-114.
Judge, state doesn't have any other questions for this witness.
All right, the argument, Mr. Smith.
Just real briefly, Judge, I do know that based on my assessment of the state's evidence and my discussions with the state and Mr. Reyes, I believe we have meritorious defense at trial. I know that always we hope to resolve these cases without the necessity of a trial. This does not appear to be an option for Mr. Reyes. Ultimately, I can say that it is a difficult request to make of a court to reduce a bond that the court set based on a no-show. But I would urge you to take into consideration that right, wrong, or indifferent, Mr. Reyes did believe that he was excused from the date that he missed. I don't know of any other incidences of failure to appear or being late or anything like that in his history with this court. So under the circumstances also, if he were to be able to bond out, it would better enable him to spend quality time with me preparing for his ultimate trial. So we'd ask that you grant that reduction to 10,000.
Thank you, Mr. Schmidt. Mr. Woodwine, any argument?
Judge, state would ask that Mr. Reyes's bond be held as is.
All right, thanks, sir. All right, then the court will take the arguments, evidence, under advisement, and issue a ruling at the end of the docket.
Thank you. I think, Judge, other than Mr. Beatty, which we are going to hold in your courtroom, is that correct?
Yes, sir.
I should have a Mr. Bennett. I'm trying to track him down. He's not in custody yet, and I haven't been out there, so I'm gonna see what I can.
Okay.
Thank you.
Judge, and for the court's information, Ms. Heisel's already on her way to the courthouse.
All right, so
this one's thing.
All right, court calls, cause numbers CR 14450, CR 22398. State of Texas versus Joe Junior Beatty Junior. Mr. Beatty, if you'll raise your right hand, sir, right there where you're at, so just raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. All right, thank you. Go ahead. You can have a seat. Mr. Schmidt, before I begin, the admonishments for Mr. Beatty, just want to go through these plea agreements. It looks like in the, motion to revoke case CR 14450, the state had filed its motion to revoke and on October of last year. And has alleged a single count. That motion. Looks like the agreement is that Mr. Beatty would plead true to that count. In exchange for the state's recommendation that his community supervision be revoked and his sentence be assessed at 6 years confinement in the Texas Department of Criminal Justice. With a credit of 194 days, is that correct? In the other charge, CR 22398, Mr. Beatty is charged with a second-degree felony, actually charged with a first-degree felony offense of murder. However, it looks like the plea agreement is that Mr. Beatty would be pleading to a lesser charge of intoxication, manslaughter with a vehicle, a second-degree felony with an affirmative finding on a deadly weapon, with an agreement of 10 years confinement in prison, plus a $1,000 fine, court costs, reimbursement fees, with 150 days credit towards his sentence for the time that he has spent in jail on that cause. Is that your understanding, Mr. Schmidt? I'm showing 194 on the motion to revoke and 153 on the intoxication. That's correct. All right. Mr. Beatty, I'm going to ask you, are you a United States citizen who reads, writes, and speaks English? Yes, sir. Have you ever been diagnosed with any mental conditions? And what? Any mental conditions? Yes, I have. Can you tell me what those are? Schizophrenia, depression, anxiety, alcohol abuse, drug abuse, also drug-induced paranoia, narcissistic, borderline personality. I've got like 17 diagnoses. Are you on medication or undergoing treatment for any of those? No. Do you feel like you have a rational understanding of the proceedings here today? Yeah, I know it. You don't feel like any of those conditions are interfering with your ability to understand what's going on in this case? No. You're represented by your attorney, Mr. Richard Schmidt. You feel like you've had enough time to work with Mr. Schmidt on your case to the point that you've had all of your legal questions answered, that you understand everything clearly? He's been very professional. Mr. Schmidt, do you believe Mr. Beatty to be competent for both of these plea agreements today? All right, Mr. Beatty, in CR 14450, you appeared before the court previously on December 7th of 2017. You pled guilty to the third-degree felony offense of driving while intoxicated, third or more. The court heard the plea agreement you reached with the state that day. The court approved that agreement, which was your sentence was assessed at 6 years confinement in TDC. The court suspended that sentence, placed you on community supervision for a period of 6 years. And then the state filed its motion to revoke your community supervision and alleged a single count of a way that you violated. And so in cause number CR 22398, you are charged with a first degree felony offense of murder. However, the plea agreement is to a second degree felony offense of intoxication and manslaughter with a vehicle that carries a range of punishment of not less than 2 years in prison or more than 20 years in prison, and a fine not to exceed $10,000. Mr. Beatty, do you understand the plea agreements that I've spoken with Mr. Schmidt about?
Yes, sir.
That's what you're asking the court to approve here today?
Yes, sir.
All right, so in your motion to revoke, Mr. Beatty, I'm gonna ask you, how do you plead to count one? Does that count true or not true? True. In regards to intoxication, manslaughter with a vehicle, how do you plead to that charge? Are you pleading guilty or not guilty?
Guilty.
And Mr. Beatty, has anyone forced you, pressured you to plead true or guilty to either one of these cases?
No, sir, not at all.
All right, the court will accept the defendant's plea of true and also his plea of guilt. Mr. Schmidt, is there any objection to state's evidence in either case? All right, state's evidence is admitted in each case respectively, and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
Yes, Your Honor. State has submitted to the court a victim impact statement that we would ask you to take judicial notice of before pronouncing sentence. Additionally, we do have some family members here, and specifically Miss Lisa Turner is here and would like to give allocution.
Ms. Hassel, anything further from the defense? All right, the court's going to view the evidence. All right, the court has reviewed the evidence in each case. Court finds that CR 14450 that upon Mr. Beatty's plea of true, that Mr. Beatty has violated the terms and conditions of his community supervision. The court will follow the plea agreement reached between the state and the defense. Court hereby revokes the community supervision of Joe Jr. Beatty Jr. Assesses punishment at 6 years confinement in the Texas Department of Criminal Justice Institutional Division. Court will award him 194 days credit towards his sentence for the time that he has spent in jail on this cause. And the court will order that this sentence run concurrently. With regards to CR 22398, court finds that the evidence substantiates the guilt of Mr. Joe Jr. Beatty Jr. Court hereby follows the plea agreement, convicts him of the lesser offense of intoxication, manslaughter with a vehicle, a second degree felony, assesses his punishment in accordance with the plea agreement at 10 years confinement in the Texas Department of Criminal Justice, orders him to pay a $1,000 fine, $290 court costs, and orders 153 days credit towards his sentence for the time that he has spent in jail on this cause. Prior to the pronouncement of sentence, the court will recognize the victim's family for purposes of allocution. The court's going to direct the court reporter to not conduct a record, make a record of this proceeding during the allocution.
Thank you, Your Honor. And state would also request that any kind of broadcasting or video recording of this be suspended at this time as well.
All right, the court will grant the state's request.
Thank you, Your Honor. And then we will call Lisa Turner.